5 former prison officials who are accused of aiding and abetting rapist and murderer Thabo Bester will remain behind bars for now. Their bail application has been postponed for closing arguments on Tuesday. The accused are former G4S employees who allegedly helped Nandipha Magudumana to help her lover, Bester, to escape from the Mangaung Correctional Centre run by G4S in May last year. And meanwhile, that big case we reported on earlier, the Durban High Court has cleared those 2 brothers implicated in one of the Phoenix murders during the civil unrest in 2021. Dylan and Ned Govender were found not guilty for the murder of Mondli Majola, but they were found guilty on a charge of attempted murder and assault to do grievous bodily harm. So a lot of very important court cases on the go. Let's discuss. We're joined by legal analyst Mpumelelo Zikalala. Great to have you with us as always, Mpumelelo. Let's start with the Phoenix case, because the others are serious cases of crime, but this was alleged racially motivated attacks, a 19-year-old killed by a mob. So many people were concerned with what was happening in Phoenix in 2021. What do you think of the outcome of this case?
Well, let's say it was half one in terms of for the side of justice. When someone has died, who's your loved one, you want to find someone that you can attach blame to. You want someone that can be held accountable and that can pay for their crimes. However, I think the ultimate prize would have been murder because it would have carried a much more heavier sentence. But if we don't have it, we leave it up to the hands of the court to find the appropriate sentence. But the court was clear in this case in terms of saying, the manner in which this matter has been investigated is not something that we should be proud of. There's certainly a lot that could have been done. Remember that the court is not there to do the investigation on the side of the prosecution. They're simply to evaluate the evidence that has been gathered. And if the evidence is so short to such an extent that it's going to lead to a lesser conviction, it does say something about the police. It does say something about the interest or the manner in which especially the investigating officer were investigating this particular matter. Almost, I must add, the causal connection of saying that the person must be found guilty of attempted murder when the person has died. I must say there must be stringent evidence which is lacking, which would lead to the court to coming to that particular conclusion, which is why I say the manner in which this matter has been investigated is a direct result of what has taken place. And unfortunately, the people who are going to suffer is the family of the deceased, and certainly they're going to say, we haven't seen any justice being done for the loss of our loved ones.
And let's remember that at least 30 people were killed in Phoenix. So a lot of justice outstanding, even in this case, that was brought to some sort of resolution, you say. Let's move to another case. In the bail application of these G4S employees accused of helping Thabo Bester escape, their lawyers have argued that the state has fallen short in showing clear evidence that they were involved. So again, this would be the evidence collection. We've seen the police officers on the stand. How have they performed, do you believe?
Performed in a manner in which maybe in the main trial they will come back with a conviction, but for the purposes of bail, I don't think they've been able to achieve that the accused ought not to be released on bail, or to say it's not in the interest of justice that they be released on bail. Let's remember that when you look at Section 6 of the Criminal Procedure Act, it simply says, are you going to be a trial, are you going to interfere with evidence? Is your life in danger in terms of public interferences in the manner in which you interact with the public? Do you know the witnesses that are there? Because you may go there and end up instilling any fear on them so that they don't come and testify at a later stage. I think the defense was quite clear in proving that, remember, court, or to say to the magistrate, remember that these individuals are still innocent, they're not yet guilty, evidence will still need to be led. We are poking holes as we speak as the accused attorneys. And definitely there's a case in which they would need to answer on. We agree on that one. But let's attach the level of innocence on them at this particular stage. So I think they were successful in saying that you are going to be released on bail, or there's nothing which would inhibit the court in arriving in that particular decision.
All right, they are behind bars for now, but we'll get that conclusion on Tuesday. Let me pick up on something that you said, that this may lead to convictions down the line. There is a lot of evidence. I mean, if nothing else, we've heard even more, that the CCTV cameras were switched off, that Thabo Bester left in a G4S security outfit that nobody checked when a body was brought into the facility. Clearly, insiders were involved. So are you hopeful that there will be justice in this case?
There is reasonable evidence that says at least you ought to answer to certain questions or certain allegations which are going to be laid against you. So let's hear what you have to say and what your response is going to be. If the allegations are so severe and they stick so much to the manner in which you conducted yourself, there is a manner in which you ought to answer those particular allegations. But you must also remember that the manner in which this particular crime was done also speaks to the procedures that ought to have been followed within a correctional facility. And I think the Minister of Justice must be sitting and watching these applications attentively and saying, here are the loopholes in terms of the manner in which we administer our facilities. Let's make sure that something like this never happens ever again. Let's make sure that we're able to vet the employees that are there, especially when we're dealing with your triple Ps, your private-public partnerships establishments. Let's make sure that the level of scrutiny, level of protection has been afforded. We are not only protecting individuals or people that are close to them, not only the victims, but we're also protecting the masses that are out there. These people are not on jail because they walked into jail and said, we've done something wrong, we should be punished. They were there due to the extensive investigation, extensive trials, and after a trial, a judge sat down and said, this is the appropriate sentence that you need to serve. So let's not let them go easily. Let's make sure that we're able to tighten up our belts and make sure that all these processes that will ensure that they stay behind bars are utilized. And this is the perfect case to say, let's look at where the loopholes are and try and close them as soon as possible.
All right, before we let you go, a quick comment on the Senzo Meyiwa murder case. I mean, around that, there has been so much controversy, conspiracy theories, the Netflix documentary, and then some controversies in the courtroom itself. What do you think about the latest proceedings? Is there a sense that the wheels of justice are turning, or we're getting closer to some truth there?
Indeed, they're indeed turning. Maybe let's look at two aspects. The first one is to applaud the court and say it played a very crucial role in balancing the competing rights that were there, rights of the accused, rights of the public, and rights also the person who's going to give witness that we know now as Nandipha. And in terms of saying, yes, we'll try so much to make sure that we're able to conceal the visuals, but we need the truth to be out there, not only for our sakes, but for members of the public, so that they can see that indeed the wheels of justice are indeed grinding. Now, the manner in which they're doing it now, I would say maybe the state is going to give some more evidence that can be able to assist it, but it does not look good for the state at this stage. One question that I always have is, why didn't the identity parade take place in a manner which is not in court? Because it's easy for a person to say, yes, it is accused number 2, when accused number 2 is sitting like a sitting duck, and there's no other person that you can be able to point to. Why not do your investigations properly so that when you go to court and present evidence, your evidence is going to be credible, it would have stood the test of time, it would have stood the test of all the other things that need to be eliminated to be able to prove that what you're presenting is indeed the truth. Yeah. But the state still has an opportunity to do that. Another lingering question is this one. Why not combine those two dockets so that we have much more credible and even more witnesses if you so need? Why ignore the context of the second docket? It may prove to be crucial at a later stage. Remember the burden that you have as a state. You must prove beyond reasonable doubt that the 5 accused that are sitting there are indeed the ones that have committed the crime. Now, if you're going to offer loopholes, alternative arguments that can be there, or alternative explanations, the court will have no options other than to let them go and say, these are not the individuals that should be held accountable for the death of Senzo Meyiwa.
Yeah, the burden of proof. Thank you for that analysis sweeping across 3 very big court cases. Mpumelelo Zikalala, our legal analyst.